Can a non-family member inherit your property when you pass away? Short answer, yes. My name is Michael Pevney, and I am an estate planning lawyer. I create estate plans for families in California. You can follow me for more estate planning information and ask an estate planning question in the comments. There's a decent chance that I will answer that question. Sometimes I'll even answer it by video. So the question is, can you leave your stuff to somebody who isn't a family member? And the general answer is yes, you can. You can leave your stuff to whoever you want. There are a couple of states, Louisiana coming to mind, where sometimes you do have to specifically leave things to children if you have them. But in most other places, and specifically in California where I practice, you can leave things to whoever you want. You can cut the kids out of your estate plan if you want for whatever reason that you want, and you don't have to give a reason. And so what's the best way to do this? What's the best way to give things to people or organizations that aren't family members? Because we don't have to just give our things to our property, to our real estate, to individuals. It can be given to a nonprofit. It can be given to an organization. I suppose you could give it to the government if you wanted to. So what's the best way to do this? First, property can be jointly titled in your name and somebody else's name, whether that be a spouse or a sibling, or, since we're talking about non-family members here, a friend or whoever it is that you want to inherit that property. And essentially what that means is, once you pass away, the other person owns that piece of property, whether that's a piece of real estate or a joint bank account or a joint investment account or something like that. We can also leave somebody as a beneficiary, sometimes for bank accounts, a POD or TOD, pay on death or transfer on death beneficiary. We can leave people things in a will. A will distributes our stuff to people when we're gone. One drawback to a will is that in most places, and in California specifically, a will has to go through probate. And probate is the government-controlled asset distribution system. Things have to be essentially signed off on by a judge, and things have to go through court, and it's open to the public. My preferred way to give things to people, whether they're family members, and in this case, non-family members, is using a trust, a revocable living trust. And that is it's a legal entity. You create it, hopefully with a qualified estate planning lawyer. You put your stuff into it, and we make sure that it gets to the people that you want in the way that you want. One of the big benefits to a trust is that it avoids this entire probate process. It's not open to public eyes, and it doesn't have to be given the stamp of approval or the seal of approval, so to speak, by a judge. Now, joint ownership also avoids probate, and so does leaving somebody as a beneficiary, a bank account or a life insurance policy or something like that. It basically all involves death certificates. But one benefit that a trust provides us over these other things that avoid probate is that it is not subject to creditors if you happen to be getting sued or going through a divorce or something like that. When you become that beneficiary of that trust, when you inherit things, a trust can provide some additional protections beyond that. But we're going to get a little bit off track here because I want to talk about making sure that family members don't get things. So how do we make sure that we do this? We want to make it very clear in our estate planning documents that we don't want certain people to inherit things, especially if these are the people that would inherit things if we passed away without an estate plan. So for most people, this is going to mean kids, if you have kids. This means disinheriting kids. How do you disinherit a child? You make it very clear in your will or in your trust that you have children or that you have a child. You name them and you say, I am disinheriting them. They are getting nothing in my estate plan. And in fact, we even put, it will be as if they predeceased me. It is as if they died before I did. Some people say a good thing you can do is you leave them $1 or that you leave them $10 or something like that, so that you didn't forget about them, kind of thing. I don't think that's a good idea. I think that's actually a terrible idea because then it gives them the ability to sue in court. Whereas if you leave them nothing, if they're not a beneficiary in any way, it gives them much less standing to show up in court and say, you know what, they didn't give me enough, or I was supposed to get all of this. Because saying who they are recognizes that you didn't forget about them. That's oftentimes, we don't want to just completely leave people out and not mention them at all, because the argument can be made that, you know what, Dad must have forgotten about me because I'm not mentioned in this will at all. And it's only the ASPCA or whatever organization you want to leave to, or your two best friends who aren't doing so well right now. But he told me he was going to leave me stuff in his will, and I'm his natural heir, so I should get a right to this. And so by saying in the document, in the will, or in the trust that this is my child and he's getting nothing, and those are my wishes, makes it very clear that you didn't forget about him, right? And so we want to make sure that that happens properly. So that's just a very brief overview of, first, you can leave your stuff to whoever you want it to. Relatives, friends, nonprofits, charitable organizations, the non-kill shelter down the street sort of thing. The whole point of estate planning is that you choose where your stuff goes when you're no longer here. And we've gone over the ways some of that can be done. Having a joint account, naming a beneficiary on an account, having a will, and my preferred option for most of the clients that I create estate plans for, setting up a living trust and making your beneficiaries whoever the heck you want them to be. So if you have any questions about this or anything else related to estate planning, you should be able to go to my website. That is either in the description or in my profile, ocEstatePlanLawyer.com. Leave an estate planning question in the comments, and better yet, follow me on whatever your platform you are watching this on. I've got 1,000 or so videos out there, and if you have an estate planning question, there's a decent chance that it's been answered in one of my videos. So I appreciate your time, I appreciate your attention, and have a good one.